What is this? This is item 2, Maloj. I had mentioned in the morning, Maloj. Item 2 may be taken up for a minute. The file of item 2, which is writ petition 1913 of 2024.
19?
I can just explain in 2 minutes, Maloj.
Yes.
Item 2's file may be kindly considered. Because this is regarding recruitment of primary teachers in government schools, Maloj. And the requirement, one of the requirements is diploma in elementary education, D.EL.ED. As a one-time scheme, Maloj, the government of India had permitted certain candidates
Diploma in what?
elementary education, D.EL.ED. D.EL.ED. Diploma in elementary education.
D.E.L.E.D.
D.EL.ED. Diploma in elementary education.
Yes.
As per NCT, Maloj, NCTE, the National Council for Teachers Education, the prescribed limit is 24 months that any person wanting to be a teacher in the primary school needs to have 24 months of diploma. The government of India, Maloj, as a one-time scheme from 2017 to 19, permitted certain candidates to do this diploma from NIOS, National Institute of Open Schooling.
Which period?
2017 to 19, the government of India permitted certain candidates to complete this course within a period of 18 months.
Yes.
The question of whether these 24 months is equivalent to 18 months came before the Honorable Supreme Court in a judgment arising out of Uttarakhand. On 28/11/2023, the Honorable Supreme Court set aside the Uttarakhand High Court judgment saying that these courts cannot be treated equivalent for all purposes. Relying upon that judgment, my lords, I am the one who has done these 18 months course. I was considered ineligible for an advertisement issued by the government of Assam, and on 2nd January 2024, the government of Assam issued a notification saying that because there is an Honorable Supreme Court judgment which says that both these courses are not equivalent, hence we will not consider it. There were multiple review petitions and applications filed before the Honorable Supreme Court, where government of Assam was also a party, my lords. And the Honorable Supreme Court on 10/12/24 clarified that both these courses are equivalent for all purposes. On 10/12/24, not just clarified, my lords, the Honorable Supreme Court also said that this clarification will be effected from the original date of the judgment, which is 28/11/23. That is also mentioned in the Honorable Supreme Court's order. Now, the present advertisement which is in question is of December 23, which is after the Honorable Supreme Court's clarification. And 2nd January 24 is the notification by which I have been removed. Thereafter, my lords, once the clarification came, most of the states, almost 9 states, have already applied the clarification. One example I want to show where Honorable Supreme Court itself applied its own judgment. My lords would now kindly have with me for a minute those 2 orders. One is the clarification order. Second is how Honorable Supreme Court applied its own order by a subsequent order, saying that whoever has done 18 months diploma will be eligible to participate in the state's recruitment process. The matter came up before my lords.
Recruitment process, even if it's advertisement is prior to the judgment of
Yes, my lord.
Is it so?
It is. Is it so? That is the point.
So?
Yes. My lords may now for a minute kindly see if my lords have item 2. The writ petition 191.
Yes, please come.
Yes, kindly come.
1913. Yes.
Yes, kindly come to page 106 for a minute. That is the advertisement. I wanted to show the date, my lords. Advertisement is one page at 106. The date on top right is mentioned.
26 December 2023.
26 judgment is of 28/11/23. 28/11/23. Which is Supreme Court judgment is prior. The advertisement is later. The judgment is 1 month prior to this.
Yes, yes.
Then kindly come a page back to 105, my lords. Where is the notification which removes me? Which is the improved notification in the writ petition. Kindly have page 105. May I read, my lords?
This is under challenge.
This is under challenge. This is under challenge. The second paragraph is important. The advertisements were prepared and published in compliance with the order passed by the Honorable Supreme Court dated so-and-so 28/11/23, which is very important, in Civil Appeal so-and-so, wherein it is stated that the qualification of 18-month diploma in elementary education acquired from so-and-so is no longer a valid qualification to be eligible for fresh recruitment to the post of teachers. This is the notification under challenge. Now kindly have, Lords, the clarification order, which is in my additional affidavit. In the very same volume, there is an additional affidavit that I have filed, which starts from page 336. 336, the additional affidavit starts.
Come to relevant.
I'm sorry.
Come to relevant page.
Yes, I'm showing the relevant page in the additional affidavit.
Yes.
My Lords, may kindly have page 347, which is the Honorable Supreme Court's order. 347 is the Honorable Supreme Court's order. And my Lords would kindly mark the fifth application number, which is 42144 of 24. 42144 of 24 is the application. I'm sorry, 347. 347, and the fifth application number, which is 42144, is a application where Government of Assam respond number 4. Then kindly come to the operative part, which is at next page, 348. Para 3 and 4 are very, very important, if I may read. However, to avoid any confusion, we again clarify that the 18 months diploma obtained by such persons who were in employment as on 10th August 2017 and who have completed the diploma course of 18 months would be treated as valid diploma holders for the purpose of applying in other institutions or for promotional revenue. Two conditions, they say. 10th August 2017, I should have been in job. All the petitioners were in job. And I have completed the course from Nios in that period. That is the condition stipulated. Fourth is very, very important, my Lord. Exactly the question that fell from my Lord. Needless to state that the clarification will be effective from the date of pronouncement of the judgment under review. Now, the judgment under review is dated 28/11/23. And this, my Lord, is then applied. So this is passed by a bench of Justice Gawai and Justice Mishra, my Lord. And then this is applied for one of the states by Honorable Supreme Court, which my Lord would now see at page 350. See how the Honorable Supreme Court is applying its own order. The earlier was a different bench passed by Justice Gawai. Page 350 is another bench headed by Justice Roy. Kindly see, my Lords, what has been applied in that matter. 350, the order starts. I had the fortune to assist the Honorable Supreme Court in this matter, my Lords, at page 350. The relevant is at 351. And I'm seeking the exactly same order what the Honorable Supreme Court has passed for Bihar. The same very order I'm seeking. Kindly see 351 now. May I read, my Lord? The the first paragraph is important. Since the Bihar Public Service Commission had issued an advertisement on 7th February 24, which is prior to clarification after the judgment, for recruitment of primary school teachers class so-and-so, the applicants seek participation in the counselling process, which is to commence from so-and-so. It is submitted that around 36,000 candidates are in fray and the present application is made on behalf of 215 aspirants. Para 3 is again very important. Miss so-and-so, learned senior counsel appearing for NCT and Mr. so-and-so appearing for NIOS support the stand. They are supporting the applicants.
Were you reading?
I'm sorry, my Lord. So this is 351. 350, the order starts where the Honorable Supreme Court, via an order dated 20th December, different bench. Justice Roy applies the order passed in clarification. So 20th December is the application, my Lords. And the relevant is at 351. My Lords have it?
Yes, yes.
So I am reading the second paragraph, my Lords, which is on top of the page. Since the Bihar Public Service Commission had issued an advertisement on 7th February 24. Here the advertisement is of December 23, after November's judgment. For recruitment of primary school teachers, the applicants seek participation in the counselling process, which is to commence from so-and-so. It is submitted that around 36,000 candidates are in the fray, and present application is made on behalf of around 215 aspirants. Then para 3, they basically say NCT and NIOS is supporting my stand. Para 4, they reproduce the clarification order. So on 20th December, Honorable Supreme Court is reproducing the order to say that to avoid any confusion, we again clarify that the 18 months is equivalent. Therefore, my Lords, at para 6, they say, in the meantime, we deem it appropriate to allow the participation of the applicants in the counselling process being conducted by the Bihar Public Service Commission. The outcome of the counselling process, so far as the applicants are concerned, be kept confidential. And this, my Lords, is again, once again reiterated at page 355. So there is a series of orders where every court is saying that please, both of them are equivalent. Therefore, you cannot deny any opportunity to the applicants herein who have completed these 18-month course. And the recent one, again, Maloj, is a detailed judgment by the Honorable Supreme Court in the Uttarakhand matter. 3 days back, we had argued, Maloj, and a detailed judgment is coming. Can I just send out the copy, Maloj?
So why don't you approach the Honorable Supreme Court?
Because the answer to that is this, Maloj. In those matters, Maloj, the matter was sub judice before Honorable Supreme Court. What the orders that have been passed, if my lord would see, these are orders passed in the transfer petition. The point that I am trying to urge today, my lord, is this matter came up on 18th March and my lord were kind enough to give us a patient hearing on that day and also have directed that is the part heard matter. The state sought an adjournment that day. 2 hours later, my lords, 2 hours later, they have taken out a list of verification of the regular candidates who have done a diploma in 2 years, saying that verification has to start from yesterday for 4,100 candidates and will continue for the next 10 days. Question that I put to myself is, Lords, would I not expect a fair participation in this entire process when the law is decided in my favor, when all courts are holding in my favor, and not once but repeatedly? In fact, my lords, the division bench of this honorable court has also held, I will show that order, my lords, that we are eligible and equivalent to participate in the same very process as a regular candidate would do. So if my lord would have for a minute this recent judgment, because this was argued just 5 days back, my lord, can I just show 2 paragraphs from this? My lord would kindly have.
Are you a fresh candidate?
I am a fresh candidate. I had applied, my lord, and I'm not been called for verification.
You are not in the job.
I'm not in a job. As of now, I'm not in a job, my lord. But as per the Supreme Court order, on 10th August 2017, I was in job. I have produced proof to that effect. The Honorable Supreme Court's order requires 2 things. 1, you should have been in job as on 10th August 2017 when you applied for this course. I was in job. I produced my proof to for all these petitioners. We have produced proof. The second thing is that why
you are not in the job now?
Maloj, I am not. Some of us may be in private jobs. Some of us, the schools have been closed. This is regarding government jobs.
Job is it will mean the employment in the government service, not just because otherwise everyone is on the job.
Yes, Maloj. So kindly have this exact point came up before the Honorable Supreme Court. Just have 1 paragraph and that will be clear, Maloj. Just 1 paragraph, my lords would have.
This is a part-heard matter.
Yes. This is a part-heard matter, but I have this only 1 second. If you don't mind. This part-heard matter, I'm not even arguing on that.
When it is likely to be? When is this fixed?
It is fixed for 8th of April, my lord.
8th of April.
But we have moved an IA yesterday because of this notification which has come out 2 days back after the hearing, 2 hours after the hearing.
Where is that notification?
Yes. Now kindly have the IA for a minute.
So are you a fresh candidate or are you a departmental candidate?
No, there is 2 things, my lords. I have applied.
What is the advertisement is for?
The advertisement is for government teachers in the state cadre. And the post is there, the vacancy is about 5,500. And I want to be appointed as a government teacher subject to fulfillment of other eligibility criteria. There are 2 sets of people who have applied for this.
So in that case, there is no question of you are in employment.
Indeed. If I have applied, I am absolutely not in a state government job as of now. Therefore, I have applied, or else what was the need to apply? So hence, my lords, the Honorable Supreme Court said that as on 10th August 2017, you should. Yes.
That is not relevant.
But I must be fair, therefore.
Whether, as per the Supreme Court, whether you are eligible or not.
Yes.
That you just show it. That's
yes.
While who are employment.
Yes.
Whether so you are that point of time you are employed or not, forget about it.
Yes. So
therefore, we will have to go along with the context of the advertisement will have to.
Yes. In terms of the advertisement.
It doesn't, they didn't ask for the departmental candidate.
No. They have said
it's
that you should have
appointment only.
I'm sorry.
Fresh appointment only.
Yes, fresh recruitment. They have said that you should have a valid diploma. I am saying my diploma is valid.
Yes.
As simple as that. That is the short point. They are, as per this notification which I read, they say my diploma is not valid, therefore I will not consider it.
Your challenge is basically page 105.
105. Which is now been overturned by Honorable Supreme Court.
I am handicapped by 2 things. 1, the morning it was mentioned, I did not have my file today with me. I don't have the reputation. I have no documents with me. Secondly, the learned AG is appearing the matter. The lead matter was, if I'm not wrong, 447 of 2024 or something. 477, which went up in appeal when the interim order was rejected. Disposing of the appeal, Honorable Division Bench has given a direction that the interim order of not declaring the results of the appellants or petitioners will remain in force till the end of the litigation. That remains, that part remains for the time being. What I was suggesting is, the notification they are challenging itself says that the verification would go up till 11th of April 2025. Matter is fixed on 8th of April 2025. By that time, we are required to file our affidavit in opposition in all the matters. Anything regarding this also we will file before 8th of April 2025. Matter is taken up on 8th of April 2025. If Lordship feels that before 11th, we should also give them an opportunity of having the
verification.
They have applied. There is no difficulty on that. Lordship gives an order on 8th, will verify it before the 11th or will extend it if necessary. Today, there is no urgency that we should now publish flash notifications allowing them to come in.
No, I'm sorry.
There's nothing like that.
What the recruitment would be, the process would be.
The process is they apply.
Including your written examination.
No, there's no written
There's no
examination. Especially
Kindly have that notification.
what happens is,
Kindly
please, for a
have
moment,
Yes,
Rishi, I was stopped when I was answering. I would request an audience. Now, my lord, what happens is they apply, there is a verification of all the documents. Their results we are not supposed to declare by orders of this honorable court. So the participation in so far as their merit is being concerned, that is already been given to them for the orders of this honorable court. Let the matter come up on the 8th of April. Perhaps you can thresh out the whole matter itself.
So I'm asking what it will be consist of written exam also?
Nothing like that. There is no written examination. The marks obtained by them in different in all the different tests, they are taken into account. A total is done. The documents are verified. Then the final merit list is prepared. That part has not come till now. It is only the document verification we are
That's why
undertaking.
I'm asking.
Hello.
After the verification, will there be a written examination?
No. Based on the marks obtained by them in the different
Under which rule you are?
under 1977 rules.
It's only based on the marks and
Documents. Nothing else. So they have submitted their documents. Records are with us. As of today, allowing
you have
them to.
submitted.
Yes.
All of us have
Well,
given
so
our
because
application.
In fact, this what about this? After the submission, only this notice was issued.
Yes, the notice was issued 2 days back. So therefore, what I wanted
And
to
I
make as
do
a fair
not even have. I do not
Notice,
even have.
Yes.
Notice. It is
kindly have the IA, the
2nd of January,
That is-
2024.
2nd of January is disqualifying me. Then is the Honorable Supreme Court's order. Now the notice has come up 2 days back where they are having verification for the regular candidate. That, my lord, will file in the IA 838 of 25, which I have filed and mentioned today, IA 838 of 2025. And the relevant page number is 35. 35.
335.
35. Only 35. Relevant page is 35. Annexure 1. If my lord would kindly have the date.
35. IA.
IA is 838 of 2025. Sorry.
836.
If item number 2, there is an IA of which is 838 of 2025.
Yes.
My lord would kindly have the date on top, which is 18th March 25.
Yes.
And this is the day when the matter was listed and they sought an adjournment. I am just reading the relevant part. It is for information to all the concerned that physical documents verification of the candidates who have successfully submitted their online application and uploaded the relevant documents in support of their candidature against the advertisement white so-and-so, which we just read, for recruitment of post of regular teachers in so-and-so under so-and-so. Date is given from 20th March to 11th.
Okay.
So they have not included us here.
It's okay. This is
First phase.
This should be first phase up
Yes.
to 11th of April.
And they have not included us here. The point that I am trying to make is, my lord,
Is there any order by this court while moving the writ petition that you should also be allowed?
yes, it is here. It is included.
No,
I have the idea.
of the division bench also.
19 number 1913.
There is an order of this court, not just this honorable court, but the division bench also, which says that we should be included in the participation.
You with the order of yeah, my
Can you just take out the other IE 836 of 25, which is an item 1. IE 836 of 25. Please take out page 67. 67. Page 67 is an order of 9th February 24. Lord, would kindly see the order of the Honorable Division Bench.
This one?
This is 9th February 24.
No, 0905/2024.
This is the one.
in item number 1.
Yes, we have just taken out, Manoj. Having heard the learned counsel for the parties for quite some time, we deem it appropriate to direct the state to provisionally allow the appellants to apply in the recruitment process initiated by advertisement dated so and so, provided that such application is filed offline before the last date, which was duly done. However, the final result of the appellant shall not be declared without leave of the court. Then please see page 86 also for a minute after this. Then that 3rd May order which my lord was referring to. First is an interim order and then the final order is 3rd May. And this was disposed of, making the interim order absolute, if I may read with my lord kind permission.
So in this, you have been only allowed to submit your application.
Indeed, my lords. And this verification is a part of that. The question that I put to myself today
The
is,
state to provisionally allow the appellant to apply in the recruitment process initiated by advertisement.
indeed, my lord. So therefore, the point that I am trying to urge,
And
then at page, I'm sorry,
order of it will be for the first page only.
first
So up
phase.
to April to 11.
Yes, and the answer.
Second page will be notified. Who knows? Your name will be.
No, there is one point there, my lord. In this first phase, none of us have been included. So the only question that I put to myself is that what stops the state from including us in the verification? I am not even asking for appointment today. The appointment, of course,
the
will be
question
subject.
of appointment doesn't arise.
Yes, so therefore, all
Your
that
eligibility is under
Yes.
under question, under challenge, under big question.
today the Honorable Supreme Court has settled that. Therefore, I was showing that Uttarakhand's order.
It's okay.
So, my lords may kindly at least permit
Fixing
us.
we have fixed the matter on 8. We'll hear it.
No,
If
yes.
not, we'll pass the
There
interim
is
order on that day.
one
We do.
aspect. There is, I'm sorry. Just
If in any
Please
case,
don't keep touching me.
if this court cannot pick up the matter, then we'll pass the appropriate.
Because there is only one request, lords. 300 people per day the verification is happening. My request is only this. Kindly consider it to be. I would question myself. If it was not a fair submission. The verification will take time. We are 1600 people before this honorable court. I am only urging, my lord,
This first phase is for how many people?
4100.
4,100.
4,100. The total posts are 5,500. So the total posts are 5,500. The first phase is 4,100 and none of us have been included. We are all put together 1,600. Now in this,
No, there is a provision. The interim production is already there. No final result.
Well, the final
will not be declared.
the final result is only coas.
No, we are hearing the matter before the completion of first phase of verification on 8th.
Because what will happen is this, Manoj, that this verification of 4,100 will be substantially completed by that time. If it is substantially completed, Manoj, what would stop? The question that I again put to myself is, what will stop those 4,100 to come before this court and now claim parity with us? So therefore, this is the why media. Can I just put this as a suggestion? Just as a suggestion, Lord, that 1,600 of us, I'm not even asking for anything more. Let us please participate in the verification.
They are
Our-
having their verification is in phases. It's
I'm
a
sorry,
first page only.
No.
Verifications are on the first
That is true, Manoj. The verification is phase.
It started with verification of 1st of April to 11th.
Kindly
First
see,
page.
Manoj, that 18th March is the order fixed. The hearing happened on that day. 2 hours later, they released this notification saying that now we'll
It's
have
all
to.
right. It's
Manoj,
all
at least we may be allowed to participate in the verification.
How can we say that now?
Manoj, there are 2 orders of this court and
See, once we determine what we're going to determine the matter before they complete the first page of verification.
Can I
on
ask-
8th.
I'll just put one last point and I'll leave it for a minute. For a minute, just have this final order passed in the Uttarakhand matter. Just for a minute, not more than that. Kindly have the final order which I tendered, Manoj. The controversy in my humble submission stands covered by the Honorable Supreme Court's order with respect to my eligibility. Just for a minute, just
I
have
agree, but then problem is you are only seeking today
my lord,
to allow them to participate, right?
in the verification. Allow me.
Just not put the methods upside down. Let them go on. It's not your scope is still there.
Because then, my lord, what will happen is
They are not saying that these would be the final. Applicants to be verified. They said first and second page.
my lord,
For
then,
first page, they'll start from these people applicants. The first to 11th of April.
then if that is the case, my lord, let them not have the
We'll
second.
provide that.
Yeah, let them not have the second phase of verification. At least that much of a.
That cannot be.
He will
Manoj,
be deprived.
Please consider me.
It's up to 11. First page will be up
No,
to
my lord,
11.
it is not. It's my lord.
It is.
Just the first phase is up to 11th, and the second phase they say will be
They'll
notified
notify.
as and when. So the point is this: if this first phase is completed, my lord, I'm sorry, I'm pushing it because there is some point which I want to urge.
Okay.
I'm sorry, my lord.
We'll consider it. If before 8th of April, if something happens, we come back.
My lord, I'm sorry, my lord. Just 30 more seconds. I won't take more than that.
Because why I'm saying because we just cannot at this moment
Yes.
until the time. Maybe we agree that the Supreme Court has decided. We agree on that.
My lord, then
We can take it. There's no quarrel to that.
no,
There is no dispute to that.
I bow down.
Since we'll be determining the matter on its own merit, we'll hear it.
The
That's why
problem is this.
there's an urgency. That's why I think we have fixed it.
Yes,
for
the problem is this. The problem is this. What we were facing as because I have dealt with Uttarakhand, Bihar, West Bengal, all of these issues. I was fortunate enough to assist the court. The problem is this. Once a third party right is created,
Sir,
Hello.
on a lighter note, इंतजार का पल मीठा होता है सब्र करो.
no, Malaj, no one can beat on that, Malaj. But okay, can I just ask as a last thing?
Yes.
At least the result of these 4100 may not be declared, Malaj. If the result is also declared, then where will I
There
declare?
already.
Malaj, that is for us. That is for us. That is not for the for these people 4100. That result is only for the petitioners. That is the problem I am facing.
Yes,
merit-
not declare.
My lord, Lordship will
Malaj,
have-
that they should
in
agree.
case-
No, they cannot be. I think they will not be able to declare
I will
it
not
because they said verification is up to 11.
Yes.
Malaj,
How can I
the
declare it
problem
before
is
it?
this. The problem is this. That on last 18th March also they said we will not do anything. 2
Not
hours
said.
later, 1 second. If
Not
you don't
said.
mind.
No,
Let me
you
complete.
It's
you
okay.
speak a lie in the court. I
Let
will
me
have to
complete,
interfere.
sir.
On 8th, I was not in the
That
court.
is
That was
result.
why the
That
time was
is the
taken.
statement
No
taken.
statement was made.
Let's do one thing.
I'm sorry.
We'll definitely consider. We're not rejecting your prayer. All right, today.
Yes.
We'll hear the matter on 8th as
Yes.
fixed.
Done.
All right. In any case, if it is not taken up for any reason, we'll take up the IA for
Done.
applicant order. All right.
Done.
Because reason is very simple. They have said clearly that there will be 2 pages. First page is from 1st April to 11 April. We'll consider that. Don't worry.
I'm sorry, I was pushing for it.
No, it's okay.
But the only reason
So
was
we'll
that
issue notice so that they can respond to it formally. All right.
Very well.
And we'll expect that
Will be done,
the
madam.
pendency,
Will be done.
we are not passing any.
Maloj, may kindly pass it, Maloj. I respectfully urge that at least during the pendency, no step may be taken. At least that much is a fair submission I could make. No further step may be taken, Maloj. At least that much.
It's okay. We'll
Maloj, I am being
on 8
On the
and you are always liberty as today, which you have done, which you have allowed.
Maloj, my
In
lord.
any case, in between, if there's something is happened,
Maloj.
even if the result is declared, whatever is there, you come here.
Maloj, they are always
You
there
come
as a
back.
guardian. There is
You
no
are
doubt
come back-
about
come
it.
back, we'll determine.
Maloj, what happens is that we have been fighting for the
Whatever
past.
you are apprehending, if it happens,
Maloj, this,
If it comes
Maloj,
to,
this merit list was
come
also
back, come back.
The matter remains
this
partnered with lordship.
This merit list was
We do
also
something, we will be
apprehended.
facing lordship.
Therefore, if my lord would recall on that day, I requested
See,
for a status quo.
considering the urgency of the matter, it has been kept
Maloj, at least
partnered.
that step, no step maybe. I don't think anyone would be prejudiced by that.
Cannot.
Till the next date, my lord. The verification may
her
continue.
dispatch-
The verification may continue. I'm not coming in way of that, but no further step may be taken till the next date of hearing. That's all.
Okay, nothing will happen.
That at least, my lord, would recall.
The government has that much of the wisdom.
My lord, if you would put it in the order, my lord, we'll at least, the fate of 1,500 of us would be saved, my lord. We have been fighting
We'll
on.
consider that.
Very well.
We're not assuring that you will be allowed, but
No, I'm not even on that.
We'll
I'm-
consider everything. We'll determine everything on 8th of April.
Very well. Case of they shouldn't take any further step. That is my delayed. That's all.
Then
After
after
question of-
till later, you will not be able to verify.
That is the only thing. Because what happens is, Manoj, what is our fate left? And that is the entire argument that was taken before the Honorable Supreme Court in multiple states. That
No, it's okay. It's okay. We'll do it
Very well.
before they complete.
Very
All right. I heard Mr. Counsel for the applicant petitioner.
In item number,
In both, huh?
in item
IA
1, my lord,
836 and 838.
H. Buragoy, my lord. In item
You are
number
for
1,
838.
in item number 1, my lord.
838.
Rishikesh, my H.
For
Buragoy,
836.
836, my lord.
IA
I,
and Mr.
Mandeep Kalra,
Ah,
98838
ah,
of 25.
applicants, the petitioners, and Mr. No, these two applications have been filed. Seeking they are applying for still the process of document verification. It's the respondent authorities has initiated by notification, notice or notification,
Notification.
dated
18th March 20. No, I'm sorry. Notice dated 18th March.
Notice dated 18/03/2025. Whereby the document, verification of documents of the applicants pursuant to the advertisement. Advertisement is
26th
28th.
December 23.
28 or 26?
26th December 2023.
12/20/22 for filling up of
Post of primary teachers.
primary teachers in 2 pages. Mr.
Assistant teacher. Assistant teacher for lower primary school.
and upper,
Assistant teacher
assistant
for
teachers for both lower primary and upper primary, my lord.
lower and upper primary schools. Mr. The first phase of verification would be starting from 1st of April 2025 to 11th of April 2024. Thereafter, for the verification of documents for second phase shall be notified later. Issue notice to the respondents, Mr. Majumdar,
My lord.
all of them.
One is
Yes. One would be for NCT, my lord, Mr. Alam.
Since Mr. Majumdar, London Standing Council for
Mr.
Elementary,
Department of School Education.
Respondent School Education, and
for NCT, my lord, responsible for I.
also entered appearance.
Mr. D. Das for CGSE. Mr. D. Das for CGSE. He was here.
You have received the copy,
Today morning.
so you don't need any extra copy.
An extra copy would be helpful, or a PDF copy would do.
We'll do it. We'll help.
Learn concept for the applicants to furnish copy, extra copies, either in hard or Either by hard or soft copy. Either by soft or hard copy.
We'll do it.
During the course of the day. After getting the land consent of the parties, land consent of the applicants, considering that the connected with petitions. It's fixed are fixed for final for consideration. For final determination.
Final as a part of
The
On
court heard on
8
08/04/2025. And also considering the verification of documents of the applicants would be taken up in 2 pages. The first page would be starting only from 1st of April to 2025 to 11th of April 2025. And after the second page would be notified.
The first phase, 20th March, it is already started.
It said to 1st of April.
No, Malad, the first phase is 20th March 25 to 11th April 25.
Not 1st of April.
Not first.
Where it is?
Malad would see page 35 of my IA on top
35.
date of my IA.
18th of
Date
No,
mentioned.
will be started with effect from 1st
First
of
of
April.
April. No, the date is mentioned, Malad, for first phase
This date when first page of physical will be
20th
started
March.
20th March.
to 11th April. So it will be ending
on
near
11th April.
11th April.
Will be started with effect from- Okay.
The date is mentioned in bold. It starts on
Okay,
20th.
first will be with 20th of March.
Yes, it
Yes.
has started.
Which already started.
Yes.
Up to 9. You just in that case. Huh? In place of 1st of April, it should be 22,
20th.
20 March to 29 of page 35. 29 March 2025, and the second page will be starting 1st of April to 11th of April. Huh? In both the 2 places, you have to take this. Huh? No, in that case, last line, you have considering it so April to 1st of April. Second page will be 1st of April to second page, huh? For which the list of candidates will be published in the due course. And on the day that the application be listed along with the connected with petitions. Listed. In the event, the connected with petitions are not taken up on the date next date fixed, the solution. Appropriate orders will be passed. The present applications shall be considered.
The second phase is starting from 1st of April.
Yes, I've seen.
So the second phase may not start at least, not at least that much of indulgence allowed mention. Because something that is already published, I understand we should not come in that phase. Second phase is yet, the list is yet to be published. 7 days matter, my lord. It was adjourned at their instance. 7 days, 8th the matter is coming. At least they can hold it till 8th. That is all that I'm saying. It's a matter of 7 days, and it was adjourned at their instance. We were ready to argue that day, we are ready to argue today also. At least that much of indulgence if my lord would get, at least no third party right should be get. That is my only grievance. At least till then. Or my lord, an alternative, if the date can be preponed from 8th to prior to 1st, even that is fine. If that is something which they would accept. Because once they publish the list, then I'll again have to come back, my lord, and trouble my lord with the mentioning and then request for 2, which my lord were kind enough to even grant it.
That would not be trouble for us. We're here for that one.
My lord, at least this much of prayer. Please do not trouble. This list may not be stayed for any reason if that is what should go on. At least the second phase should not start because we are 1600, my lord. And how many vacancies would be left? 1400. So we are already short of vacancies. The verification is going on for the second phase. Please, that much, my lord, indulgence may be kindly be granted, my lord. Especially when state of Assam was a party before the Honorable Supreme Court. 10, 12, when the matter was heard, there were parties. They should have implemented automatically the order till now. Still, they're not implementing. And all these orders that have been passed by my lord, the division bench single judge, is prior to the Supreme Court order. It's prior. Post 10, 12, the sum and substance of the matter has changed with due respect. Therefore, at least that much of indulgence, my lord, we 1600 jobless people deserve, lord.
Okay, since you have not started the second phase
My lord, just for one.
till next day.
No, one thing. Per day, there will be around 300. 400. My lordship will just
wait. However, considering that the second phase is yet to be, second phase of verification is yet to be started, and no names of the applicants have been published till the next date, that is 08/04/2024.
my lord, in that case, may I
The-
pray, my lord? Matter will be
the-
taken up on Monday. Let the
the-
AG be
the-
here, my lord.
Verification of the second phase may not be taken up.
My lord,
So deeply grateful, my lord.
may I pray, my
So
lord?
deeply
Matter will be
grateful.
taken up on 24th.
Balance.
My lord, let it be on 24th. My lord, the entire process from 1 to 7 will go back in I'm just making a point, my lord. If in case the petitioners stand to lose out in the repetition, from 1 to 7, our entire verification goes back. That the state suffers. That 1 to 7, those 300 per day, 2100 candidates go back for nothing. They are not even before this court. They are qualified with or without a Supreme Court order. They are losing out on their verification without them being a party in this repetition.
What do you say about the Supreme Court judgment?
But on the Supreme Court judgment, the Supreme Court, the first paragraph is never referred to by the petition. I'll just make a point. First paragraph is never referred. We do not interfere in the review petition. We do not like to interfere in the review petition. What the Supreme Court in Jaivir had said, unless the recruitment rule contains a provision allowing 18 months or the NCTE declares 18 months to be equivalent to 2 years, there can be nothing which will allow 18 months diploma holders to participate afresh. When this was put forward in the review petition, the Supreme Court clarified that if there is a provision in the rule or there is a provision by the NCT declaring a equivalence, only in such circumstances or a clause is contained in the advertisement. The Jaivir judgment was very beautifully assessed in this honorable court,
Sir,
point 477.
We are not allowing the petitioners to.
That is the whole thing.
Directing them to verify
The persons who are not before this honorable court and are having 2 years diploma, if lordship passes this order, they will not be verified from 1 to 7. 2100 people, my lord.
7 days.
Monday.
Well, consider.
My lord, that will go back by 7 days
Okay.
for the entire state, my lord. It could have been preponed if this was it, my lord. I would have preponed it to 24. I would have the AG here arguing the matter, my lord. Doesn't go on my shoulders, my lord. I don't even have the writ petition. I'm told today morning there is an IA. It could not have been informed to me yesterday evening. Come prepared with the file. Statement is made 18th. I took a time, my lord. I was standing in court number 1. Not because I did not want to do a matter.
So you make a mention next week if there is urgency, because second page, we're only
Whatever he came out and
asking them to go into second page, which is yet to be started.
Yes, madam.
You make a mention next week
Yes, madam.
if you think that there is urgency.
No, Monday. Whatever interim.
Yes,
So we make a
next.
So
Obliged,
deeply grateful, my lord.
Obliged, madam.
Grateful for a patient hearing, my lord. So deeply grateful.
Obliged.
Yes, yes.
Yeah,